I will introduce you to our speaker, who I'm excited to welcome back to Harvard Law School. She's Professor Delcianna Winders, who directs the Animal Law Clinic at Lewis and Clark Law School, the world's only law school clinic dedicated to farm-to-animal advocacy. Her scholarship has appeared in numerous law reviews, and she has published extensively in the popular media. Prior to joining Lewis and Clark faculty, Professor Winders was Vice President and Deputy General Counsel for the PETA Foundation. She was the first academic fellow for the Harvard Animal Law and Policy program, so welcoming her back, that's a very special place in the Harvard Animal Law and Policy program history. She's also been a visiting scholar at the Elisabeth Haub School of Law at Pace University. She has also taught animal law at Tulane University School of Law and Loyola University, New Orleans College of Law. She frequently gives talks on animal law subjects, has been interviewed by many major national and international news outlets, and was featured in Oprah Magazine as one of the 6 women who dare. Very cool. Winders received her BA in legal studies from the University of California, Santa Cruz, and her JD from NYU School of Law. And following law school, she clerked for the United States Court of Appeals for the Sixth Circuit. So please give a warm welcome to Professor Delcianna Winders.
Thanks, Gabe. Thanks, everyone. You can hear me okay?
I'm sorry, I forgot to make one important announcement. We're all being recorded here, so just, you gave me permission by being here to be recorded. And when we're doing questions at the end, please wait for the mic. Sorry, go ahead. Thank you.
No, I have to make one correction to the bio. I know it was so long, I'm sorry. So I teach the Animal Law Litigation Clinic at Lewis and Clark. We're the only law school in the world that has 2 animal law clinics. So we have the Animal Law Clinic, which we've had for more than a decade, and that's taught and directed by Professor Kathy Hessler and tackles a broad range of animal issues and all areas of the law. And then we have the new Animal Law Litigation Clinic that just launched this past fall and is all litigation and all farmed animals. So I know it's confusing, so I just wanted to set the record straight on that. So you might have noticed, or maybe you've heard, that we're in the midst of a deregulatory era. On the campaign trail in 2016, Donald Trump ran as a deregulator and frequently invoked what he termed overregulation. It was an important platform issue for him. 10 days after being sworn into office, he issued an executive order titled, quote, Reducing Regulation and Controlling Regulatory Costs. And this executive order created what has come to be called the 2 in, 1 out, or 2-for-1 rule. It required that, quote, whenever an executive department or agency publicly proposes for notice and comment or otherwise promulgates a new regulation, it shall identify at least 2 existing regulations to be repealed. This executive order further directed that total incremental costs of all new regulations be no more than 0. A few weeks later, Trump issued another executive order to, quote, alleviate unnecessary regulatory burdens, which called for the creation of a regulatory reform task force inside of each agency, which was responsible for evaluating all existing regulations and making recommendations on which ones to get rid of, basically. And to regularly report on what they were doing and what should be repealed, replaced, and modified. And in all of this, it's been clear that the concern about regulatory burdens is very much about burdens on businesses. At the end of fiscal year 2017, the administration claimed success and reported that it had accomplished 67 deregulatory actions. End of fiscal year 2018, that was up to 176 more deregulatory actions. And then at the end of fiscal year 2019, they claimed another 150 deregulatory actions. There's been some critique about whether this scope is really as big as it seems. Some of these things were already slated to happen before Trump took office. Scholars have argued that there are actually far fewer regulatory burdens have been reduced than the public believes. And there have been some empirical studies that have found the actual deregulatory effects to be modest. But I would submit that the effects on animals have been anything but modest. As you might expect, removing protective regulations hits the most vulnerable the most, and animals are among the very most vulnerable. And it's not like we ever had a robust federal regulatory system of protections for animals. We had some protections, and even those protections have been scaled back significantly. So just to give you a flavor of a few of the deregulatory actions that we've seen in the last few years that impact animals, the current administration withdrew a rule that would have banned the practice of soring horses, which is using devices to inflict pain on them when they're used in shows so that they lift their feet up higher and faster than normal. The administration reversed a ban on the use of lead bullets on federal lands that was intended to reduce wildlife poisonings. They ended a measure that was intended to protect sea animals from getting caught in fishing nets. They lifted limitations on hunting and fishing on public lands and public monuments. They overturned a rule that would have set higher welfare standards for animals whose flesh is sold as organic. They overturned a ban on the import of elephant trophies. There was a lot of coverage around that. They reversed long-standing interpretation of the Migratory Bird Treaty Act to basically go from a strict liability interpretation to say that unless your purpose in an activity is to harm birds, you're not going to be held liable under that act. So even catastrophic things like Deepwater Horizon would not be considered violative of the Migratory Bird Treaty Act under this current interpretation. And of course, there have been significant, numerous major rollbacks to the Endangered Species Act. I want to focus today on just two of the deregulatory approaches under two statutes, which I think are the most important federal animal protection statutes, or among the most. And those are the Animal Welfare Act and the Federal Humane Methods of Slaughter Act. And I'll start with the Animal Welfare Act, and then I'll turn to the Humane Methods of Slaughter Act. So, as you may know, the Federal Animal Welfare Act is our most significant federal animal protection law. It is intended to ensure the humane care and treatment of animals who are used for the commercial pet trade, for exhibition, and for research, and it does so through a licensing and inspection regime. And there actually haven't been significant formal regulatory changes under the Animal Welfare Act. To be sure, there were some regulations that were slated to be pushed through, including updated regulations for marine mammals and long overdue regulations for birds, and those were tabled. But I'm skeptical that they were actually going to see the light of day anyway. They've been in the works for literally decades. The deregulatory impact under the Animal Welfare Act is more informal. And it takes the most significant form, in my view, is a significant drop in enforcement actions and an assault on transparency. So I'll start with the enforcement actions. First, enforcement has never, ever been good under the Animal Welfare Act. In all of its more than 50 years, it's never been adequately enforced, and it's not just me saying it, although I have said it, including in some of the scholarship I worked on while I was here at Harvard, but it's the USDA's own Office of Inspector General has said it in audit after audit after audit, including that the USDA's enforcement of the Animal Welfare Act is, quote, ineffective, that the USDA has assessed penalties that are, quote, basically meaningless, and that are so low that violators treat them as, quote, a normal cost of doing business rather than a deterrent. So we didn't have a good situation to start with, but as the Washington Post and ABC have both reported, this already inadequate enforcement has plummeted in recent years. And the USDA has been clear that this is a conscious policy choice. It's not some accident that inadvertently happened. They just weren't prioritizing this. This was very deliberate, and they have started referring to the members of the industries that they're supposed to be regulating, the research facilities, the dog breeders, the roadside zoos, et cetera, as their, quote, customers, and have been very explicit that they think their mandate is to help support them in coming into compliance and to focus on education rather than enforcement. And in fact, the agency tried this before in the past, and the Inspector General specifically addressed that and said, this is not working, you cannot do this. You need to take enforcement at least against those intransigent folks who you try educating and continue to violate the law. Nevertheless, this is what USDA is doing now. So in fiscal year 2018, the agency opened only 19 Animal Welfare Act cases, and this is for more than 12,000 locations using more than 2.5 million animals who are regulated under the Act. Compare that to fiscal year 2016, before Trump took office, there were 239 cases. And that's in line with the number that there had been in all the many, many years preceding that. So it was a really precipitous drop. And you might be wondering, okay, what about fiscal year 2019? Because that ended almost 5 months ago. What are the stats there? We don't know. The USDA still has not posted those statistics. Before this administration, enforcement statistics were regularly updated, and the enforcement actions themselves were posted every single month. You could see, here are the actions that we took last month. No more. Which brings me to the next point, which is the withholding of information. So in addition to drastically scaling back enforcement of the Animal Welfare Act, the agency has basically made a wholesale assault on transparency. So on February 3rd, 2017, exactly 2 weeks after President Trump took office, the USDA abruptly and without any warning whatsoever and with very little explanation really, took down thousands of Animal Welfare Act enforcement records that had been posted on its website for many years. There was massive uproar, of course, from the animal protection community, also from members of Congress, also from many in the regulated industries who said this information is our license to operate. The public wants to know what we're up to. This is how we're held accountable. There were a few smaller trade organizations who lauded this, but there was a lot of opposition. So there was a series of lawsuits, 2 of which I was a plaintiff in, they're ongoing, to try and get this information restored under the Freedom of Information Act's affirmative disclosure mandates. I actually worked with Professor Meyer on those. Congress has repeatedly indicated in spending bills that it wants the USDA to address this. There's been all sorts of efforts, letters from members of Congress, like massive sign-on letters, and the USDA has just ignored it. So finally, this past fall, Congress got serious and saw that it needed to be a little bit more explicit, and in a spending bill laid out detailed requirements in an appropriations bill about restoring the records. President Trump signed this into law December 20th, and it gave the USDA 60 days to restore the records, and the 60th day was yesterday, and I was very curious to see what, if anything, was going to happen, and actually shocked to see that yesterday all of the inspection reports were reposted without the redactions. It's amazing. So for the first time in more than 3 years, we have access to this information, which is really, really huge. We still don't have the enforcement records. They say they're working on that. There's some open question as to whether they're going to include their warnings and settlements, which comprise the vast majority of their enforcement actions. It's very rare to take formal enforcement. So there are some things that we need to hold our feet to the fire on, but it's a really huge step. But of course, it's just information. This isn't a substantive change. So what can we do to address USDA's ongoing enforcement failures? And access to this information definitely can help because it gives us the means to step in and do the USDA's job for them when they're not, whether that's going to state and local law enforcement, bringing citizen suits where the animals happen to be protected under the Endangered Species Act. But in terms of addressing this in a more holistic manner, it's really challenging. So if you've taken administrative law, I hope you know that it's virtually impossible to challenge an agency's enforcement decisions or an agency's decisions not to enforce. And that comes out of 1985 Supreme Court decision, Heckler versus Cheney. They're presumptively unreviewable if an agency's decision not to take enforcement action. Of course, as you know, a presumption can be rebutted, at least in theory, and the court in that decision, in its footnote 4, a very famous footnote, said that maybe if you had a case where an agency had, quote, consciously and expressly adopted a general policy that is so extreme as to amount to an abdication of its statutory responsibilities, perhaps then the presumption of unreviewability could be overcome. It's an incredibly high bar. You need an agency basically saying very explicitly that we're just not going to do our job at all. So that's an uphill battle. And while we can sort of piecemeal help some of the animals, including through the Endangered Species Act, because it has a citizen suit provision, unlike the Animal Welfare Act, that's only a small category of the more than 2.5 million animals who are supposed to be regulated under the Animal Welfare Act. So folks have been trying other avenues, and one that has been really successful, and I think there's a lot more potential here for a lot more to be done, are state and local laws. So the Animal Welfare Act expressly does not preempt state and local laws. To the contrary, it provides that the welfare standards, quote, shall not prohibit any state or political subdivision of such state from promulgating standards in addition to those standards promulgated by the Secretary of Agriculture under the Animal Welfare Act. And so under this, an increasing number of states have enacted retail pet store bans, basically bans to prohibit the sale of commercially bred animals. Most of them are focused on dogs and cats. Sometimes they include rabbits as well. And a few hundred localities have now enacted these. I got to work on one of these here in Cambridge with Laura Hagen, now the HSUS Massachusetts State Director. And that one actually covers all land animals, which was huge and I think really important. And then we're starting to see this trickle up to the state level. So California and Maryland have enacted retail pet sales bans. And there is legislation pending elsewhere, including New York, and I believe here in Massachusetts as well. So talk to Laura if you want to get involved in that. Similarly, we've seen a lot of action on the local and state level for traveling wild animal acts, who are, again, supposed to be regulated under the Animal Welfare Act, but often not. And so well over 100 localities have local ordinances that ban or restrict the use of wild animals in traveling acts. And then on the state level, New Jersey, Hawaii, and California have banned them. Again, when I was here, I got to work on Cambridge ordinance with Laura. And again, I believe Massachusetts is looking at this as well. So get involved. So I think there's a huge amount of hope at the state and local level. And the industry is realizing this. So we're starting to see some backlash. We're starting to see legislation introduced in the state houses to preempt localities from enacting these laws. And sometimes they're flying under the radar and folks are not realizing what they are. So it's really important to be vigilant to look out for that, because localities don't want these things happening in their communities. Bigger industries are going into the state houses and saying, hey, we don't want anyone regulating us, so please enact this legislation to protect us. So we're seeing that more and more. They've caught on, so please pay attention. So that's the Animal Welfare Act in a nutshell. I'm going to shift gears and talk about the Humane Methods of Slaughter Act. I have been asked not to be graphic. That's not usually my MO. I worked for PETA for almost a decade, and I think it's part of my mission to let people know what animals are enduring, but in light of the fact that you're eating lunch, although I think most of you are done, but I'm still going to strive to comply with the request that was made to me. So as you may know, there's no federal law governing on-farm treatment of animals. We only have federal law governing their transportation, the 28-hour law, and then their slaughter, the Humane Methods of Slaughter Act. And the Humane Methods of Slaughter Act was enacted in 1958 and amended in 1978. And it requires that livestock be humanely slaughtered, and importantly also that they're handled humanely in connection with slaughter. So those are two different pieces of it. As an important aside, I don't have time to go into a lot of detail about this, but the Humane Methods of Slaughter Act specifically applies to, quote, livestock, and the USDA has opined that that does not include birds. So although chickens comprise more than 95% of the land animals slaughtered in this country, they are not being protected under the Humane Methods of Slaughter Act. So we're primarily talking about pigs. Pigs are about 75% of the mammals who are slaughtered. The rest are cows, sheep, goats, some bison, but primarily pigs. And the Humane Methods of Slaughter Act is incorporated by reference into the Federal Meat Inspection Act. I'm not going to go into the weeds on that, but just know that they're very intertwined, and the implementation measures for the Humane Methods of Slaughter Act are through the FMIA. So together, these two laws have long been understood to require humane handling of animals at the moment they arrive outside the slaughterhouse. Not when they're there, not when they're about to have their throats slit, but when they arrive at the gates, and that they be handled humanely during the entire time that they're there. And one of the explicit statutory mandates is that USDA inspectors are supposed to inspect the animals, all of the animals, before they're allowed to enter. And that's really important, obviously for food safety reasons, that you're not allowing sick animals to enter, but also for humane handling reasons. It's estimated by industry studies that more than 500,000 pigs arrive at the slaughterhouse too sick to stand or walk. And those animals, there's a huge incentive to drag them, to force them to stand, and it's important to have oversight of them from the moment they arrive. The Act also requires that animals aren't supposed to be forced to move at more than a normal walking pace. Electric prods and slappers are allowed to be used, but they are not supposed to be used more than needed. And so for all of these reasons, it's really important that this be enforced. And the USDA itself has said that those frontline inspections before the animals are allowed to enter the slaughterhouse are, quote, often the best way to detect potentially devastating diseases that may be spreading through livestock populations. And has also said that agency veterinarians can be on guard to alert other officials who can act to prevent widespread economic harm and disruption of the federal meat supply. So it's pretty important in the zoonotic era that we're in. Coronavirus is a zoonosis, obviously. There's one scientist who I've seen that thinks that pigs are implicated. I haven't heard that elsewhere, but African swine fever has killed more than a quarter of the world's pig population right now, and the USDA is spending millions of dollars to try and make sure it doesn't get into the United States. Some people think it's just a question of when it will reach here. So those inspections are really important, in short. And then in addition to that, under the Humane Methods of Slaughter Act, the USDA has long had in place, through regulation, line speed limits, a limit on the number of animals you can kill per hour. And that's based on an assessment of how quickly an inspector can fulfill their various duties, everything that they need to look at on the animal to ensure humane handling as well as public health and safety. And so for many years, regulation provided that 1,106 pigs could be killed per hour, which is already a lot of pigs and very, very fast. And all evidence, including, again, reports from the USDA's own Office of Inspector General, indicate that at this speed, there were already a lot of humane handling violations and food safety issues occurring. Nevertheless, on February 1st, 2018, the USDA announced that it was going to modernize swine slaughter and proposed a rule to allow pig slaughterhouses to opt out of that line speed limit, while also allowing slaughterhouse personnel to conduct those frontline inspections instead of USDA inspectors, despite the fact that the statute says USDA inspectors need to do that. The reason for proposing this, you can probably guess, quote, reduce the regulatory burden on slaughterhouses. The USDA, in proposing this rule, determined that slaughterhouses responsible for killing 93% of the pigs in this country would opt into the reduced oversight. In response to the proposed rule, they received more than 83,000 comments. The Washington Post did an analysis of those comments and found that 87% of them were negative. And the opposition, again, didn't come just from animal protection advocates. It came from consumer safety advocates. It came from USDA inspectors who went on record speaking out against the problems with this. It came from current and former slaughterhouse workers. It came from labor unions, veterinarians, etc. It was very, very broad opposition. In fact, the USDA acknowledged that, quote, only swine slaughter establishments, trade associations representing the pork industry, and a few private citizens supported the proposed rule. There was a lot of evidence submitted to the agency about why this was problematic, a lot of it based on the agency's own records and the agency's own Inspector General reports. But nevertheless, October 1st of last year, the rule was finalized with very little changes, no changes with the areas that I've been focused on. So, what can we do to address this pretty massive deregulatory move that poses risks for millions and millions of animals as well as consumers? We are a little bit more limited than under the Animal Welfare Act because the Federal Meat Inspection Act actually contains a pretty broad preemption provision. It says that states cannot impose requirements that are in addition to or different from those in the Humane Methods of Slaughter Act and Federal Meat Inspection Act. So that means it doesn't matter if a state enacts something that's consistent with the Humane Methods of Slaughter Act, it's just additional. It doesn't matter that it's not conflicting. It cannot regulate in that space. And that was confirmed in 2012 in a Supreme Court decision, a unanimous decision written by Justice Kagan, National Meat Institute versus Harris, which interpreted the provision to prohibit a California law that would have prohibited slaughterhouses from even just accepting pigs who were too sick to stand or walk, from letting them enter. So that avenue is a little bit more limited. We can't go the state and local route that's been showing so much hope in the Animal Welfare Act context. So what we do have here, there are 3 lawsuits currently pending challenging this final rule to deregulate pig slaughter. The first was brought on behalf of workers in these slaughterhouses. The second was brought by my Animal Law Litigation Clinic on behalf of Farm Sanctuary, Animal Equality, Animal Legal Defense Fund, the Center for Biological Diversity, Compassion Over Killing, which is now Animal Outlook, so we just had to amend our complaint yesterday to reflect that, Mercy for Animals, and North Carolina Farm Safe, so a pretty big coalition. And then a third lawsuit was subsequently filed by consumer protection groups. So I'm going to focus on the lawsuit that we brought, not just because we brought it and I know it best, but also because it's the only one that focuses on what's happening to the animals and the implications for the animals themselves. So we have 3 claims in this lawsuit. The first challenges the delegation of the inspection of the animals when they arrive at the slaughterhouse as both inconsistent with the clear statutory mandate that USDA itself do these inspections, and also arbitrary and capricious based on all of the evidence that was submitted to the agency and that the agency had in its own records. The second claim challenges the revocation of the line speeds limit as arbitrary and capricious based on all of the evidence, including evidence that Compassion Over Killing conducted in a high-speed pig slaughterhouse, a pretty egregious violations. And then the third claim is that the USDA violated the National Environmental Policy Act in promulgating this rule because they did not consider environmental impacts at all, despite the fact that they said that this rule would increase the number of pigs killed in this country every year by about 11.5 million. Killing that many more pigs obviously has significant impacts at the slaughterhouse level in terms of wastewater, transportation pollution, etc. But it also, at the supply level, has really significant impacts because that's 11.5 million more pigs being factory farmed every year, and it's well documented that there's significant air and water pollution coming from factory farming pigs. So despite that, USDA said, no, we don't need to consider environmental impacts at all. So we brought that suit. So that's how we're challenging that deregulatory move, and we're asking, of course, that the rule be set aside, as are the folks in the other 2 lawsuits. So to wrap up so that I can spend some time hopefully answering your questions and talking with you all, some would say that Trump hasn't accomplished as much on the deregulatory front, although I don't think most would say that, but I think it's important to acknowledge that there are some, including scholars, who say that it's not as much as it seems to be. I think a really devastating amount has been done when we're talking about animals specifically, and that for those of us who care about animals, it's really important to fight back on multiple fronts. And that includes holding the feds accountable through litigation and also through legislation. A lot of members of Congress are not happy with what's happening, and that includes through funding bills. There's a lot of potential, they're often overlooked, but that's how we got the Animal Welfare Act records restored after a number of other avenues and fights on multiple fronts. That was what ultimately did it. We also need to be looking at state and local laws, at least where there's not such a clear preemptive provision as we have in the Humane Methods of Slaughter Act. And then I'll just say, long term, I think we need a separate agency that's responsible for enforcing animal protection laws. I think it's very clear that the USDA, not just under this administration, but under literally every single administration, has shown a total lack of will to protect animals and should not have responsibility for these statutes. And obviously that's not going to happen today or tomorrow, but I think it's something that we need to start talking about, and that needs to happen. So I hope you have questions.
So yeah, we're just recording, so please wait for the microphone. Elisabeth will come up to you with the microphone before you ask your question.
I'm wondering, specifically with the USDA removing the records that you talked about, it seemed like that was so unpopular, like even the industry didn't want it, Congress didn't want it, the president was willing to sign the bill countermanding it. Where would the motivation within USDA to do that come from?
Yeah, I think that's a question that overlays a lot of this stuff, particularly with the Animal Law Act. Like, why aren't they doing more? With the records, they claimed that it was to protect privacy interests of small businesses and folks who lived on their property. They asserted that it was out of concerns of violence by animal rights activists, which was very 1990s of them, honestly. There's no such recent evidence. So they were getting a lot of pressure from a very small segment of industry, and it came in large part from the Tennessee walking horse industry, who's also regulated by the same sub-agency of USDA and didn't want their records posted. And then a lot of the smaller dog breeders as well. That's where a lot of the pressure came from. And it goes back to this trend of really not wanting to burden businesses at all and looking at small businesses and potential impacts on them. And so they had more of an ear in the government. Kathy has, yes, please.
Hi, Kathy Meyer, director of the Animal Law Clinic. Some of it was because groups had started to use the inspection reports to identify the particularly egregious violators of the Animal Welfare Act, and we started bringing these lawsuits challenging the renewal of the licenses of these exhibitors, in particular, these roadside zoos. And we were successful in getting the DC Circuit to issue a decision that said, if you can show that, basically the day before the entity got their license renewed, they were in blatant violation of the Animal Welfare Act standards, that would be fodder for an arbitrary and capricious claim. And so it really came on the heels of those challenges because the industry didn't want us to have the inspection reports in order to make that evidentiary showing.
Yeah, they've never acknowledged that. They've cited to the settlement with the Tennessee walking horse entities, but yeah, that's definitely at play.
And just following up on that, can you talk a little bit too about how wasn't there supposed to be an update to the enforcement of the Horse Protection Act that was like one day away from being published, and then that got pulled back as well?
Yeah, that was the first example I gave of a deregulatory move. So the rule to prohibit soaring of horses, basically using devices to force them to step very high and very quickly, was a measure under the Horse Protection Act that groups had been pushing for a very long time, and that had just gotten finalized on the tail end of the Obama administration, and then as soon as Trump came in, that was vacated.
I might have two questions, I'm not sure yet. The first, a common argument I get back from the other side when I ask, what would stop if this all makes common sense to not treat, sentient beings this way? What's the counter argument to not do it? And they would often bring up the businesses, the jobs, the role that these companies are playing, so if you didn't have the animal industry at all, that would be a bad outcome of it and a reason to keep it around. I personally don't agree with it, but I want to get a more objective opinion of what's the consequence of an animal industry-free society, or how would you differentiate between these very large animal farming businesses and then a small mom and pop, farm doing things humanely?
There's a lot to say there.
Sorry.
I have more than 2 answers, and I won't get to all of them. First, I think it's important to note that what we're talking about here isn't getting rid of these industries. We're talking about enforcing long-standing laws that Congress had put in place many years ago, and that were being enforced at some level, albeit not adequately. And it's interesting you raised the worker question, because like I said, the first challenge to the line speeds and deregulation of pig slaughter was brought by the workers, and they are very much at risk under these increased line speeds. They are just as much at risk as the animals because of the repetitive motions that they're forced to engage in so quickly. So I think regulating these industries really goes to protect workers as well. But you're asking a bigger question, I know, about what if we were to get rid of these industries altogether. And there are groups doing amazing work on that front right now. Mercy for Animals has a farm transformations program that's actually working with folks in these industries to try and transform if you will, to plant-based alternatives. The chicken farmers in particular are really exploited by the consolidated corporations that they work for and are stuck in these really, really awful contracts, and they're trying to help them get out of those. Animal Outlook, formerly Compassion Over Killing, is working in this space. So there are a lot of people working in this space trying to create new industries while attending to the fact that, yes, there are people we're talking about who do make their livelihoods here.
What do you think about the USDA moving departments to Kansas City? Is that affecting this litigation at all?
So the USDA's move to Kansas City affected a lot of workers for the USDA, but it hasn't affected the litigation. And the one area I could see it potentially being an issue is venue, but our venue is actually, we're in the Western District of New York, because that's where one of our plaintiffs, Farm Sanctuary, has its headquarters and one of its sanctuaries. So it hasn't been an issue for this, but I know it has been elsewhere for other folks.
So all the pigs that were too sick, what would happen to them if they weren't killed in the slaughterhouse? What did they do with them?
Yeah, that's a really good question, and that goes to a lawsuit we filed just a couple weeks ago, a second lawsuit that the clinic filed regarding pig slaughter, and that is focused specifically on those pigs. USDA was instructed by Congress in 2002 to address that issue and has failed to do so. In addition, a coalition petitioned the USDA in 2014 asking that they ban the slaughter of these animals and, to your question, require that they be humanely euthanized. And so we're challenging the denial of that petition as well as the failure to follow the 2002 congressional mandate. However, it's important to note that if the slaughter of these animals were prohibited, the truth is far fewer of them would be arriving at the slaughterhouse in this condition. Part of the reason that they're arriving like that is because it's allowed, and they're still allowed to go into the food supply, and so there are incentives in place to send weakened pigs to slaughter, particularly breeding sows who've been bred over and over again till their bodies have just gone out, and pigs who've been fed ractopamine, which is a growth-promoting drug that's prohibited in most countries but still allowed in the US and is well documented to cause a host of problems in pigs, including just collapse and sudden death and lameness. And so the USDA banned the slaughter of downed or non-ambulatory cattle and calves quite a few years ago in recognition of the fact that there were incentives to send weakened animals to slaughter. And in fact, they have seen that now that that's banned, they're not seeing as many animals in that condition arrive in the first instance. So by prohibiting the slaughter of these animals, it's really getting at not just that moment when they arrive at the slaughterhouse, but their time in transport, their time on the factory farm.
What law or regulation is permitting these companies to put pictures of happy cows and happy pigs and everything on their logos and everything? And then follow up to that is, can a regulation exist successfully to force these companies to make sure it's very transparent where everything is coming from and how?
That's a good question, which also requires a lot to elaborate on. There's a lot of work being done in the consumer protection space right now at challenging exactly these things. PETA brought a lawsuit challenging the happy cows thing several years ago. There's a lawsuit against Ben & Jerry's for its depiction of cows. So there are a lot of people working in this space, and they're working under consumer protection laws. There's also the Federal Lanham Act that you can sue under. Historically, you've had to be a competitor to sue. I think that's opening up a little bit now. But there's no strict regulation as to what you can say about these animals. Indeed, we're seeing the regulation go the other way, where they're prohibiting calling plant-based milks milk and hamburgers, etc. I'm sure you've heard about. So I think there could potentially be space there. You need to be really careful to not run afoul of the First Amendment, given interpretations of corporate speech being protected. But there is more that we could do there, and there's more that we could do just to require transparency so that folks have the ability to challenge what they're being told. No other questions?
So with the records going back online yesterday, because that was an appropriate bill, I assume that we're going to have to go through the same action again this year of advocates getting the same language put in the next fiscal year appropriations bill?
It's a good question. It probably wouldn't be a bad idea to do that. We're kind of waiting to see how they respond, particularly as to the enforcement actions. I mean, this language requires them to continue posting on an ongoing basis, so it does have a continuing mandate in there. But I suspect that I think we're going to need tweaks regardless. I think they're going to try and get around things, and we're going to need to update it and keep pressure on them.
So kind of a part B to that.
Yeah.
I assume that you and PETA and ALDF will continue to vigorously pursue your lawsuits at the same time, just to ensure that there's some, maybe stronger outcome than Congress on this issue?
Yeah, so that's under discussion right now. As you can imagine, the USDA is arguing that the cases are moot now. Right. They're obviously not moot right now because the enforcement records still aren't posted. And so we're evaluating what to do and how we can get ongoing reviewable duties from the agency. Yeah, good question. Anyone else? All right. Oh, Gabe.
Thank you again for coming. This has been a great talk. I'm just wondering if you could elaborate a bit more on some of these new state laws you're talking about that are getting in the way of municipal actions. You're saying they're kind of sneaking them in. I'm wondering, is the language sneaky, or just that it's not enough publicity around it? What kind of things should we be looking out for, and are there any states that kind of need attention right now?
Yeah, good questions. So we've seen it most in the context of the retail pet store bans, and mostly, I think, in the Midwest, where a lot of these commercial dog breeders, aka puppy mills, are located. And sometimes they're slipped into bills that are specious. They seem like, oh, they're gonna regulate dog breeding, and they have some like minimal protections, or they require disclosure of Animal Welfare Act information, which is a whole other issue because it ties the two things together. But then buried in there will be language that, now that we have this state protection, you can't have any more protective local laws. So that's one form it takes. So that's one thing I would say. If you see something that looks good, that's on the issue that you care about, read it really, really carefully, because there might be something buried in there that has a really significant impact about your ability to do more in the future or to do more elsewhere on the local level. And then I've seen this also in the factory farming context. So this doesn't go to the federal issues, the federal deregulation exactly, but we've seen a lot of laws, for example, requiring really significant setbacks of concentrated animal feeding operations, like more than 2 miles. They can't be near other things. So that makes it really hard to open one of these operations. And I just saw a bill in Utah that was introduced about a week or two ago that just, it's really not clear what it's doing, but what it's saying is that the state cannot enforce setbacks, or sorry, the local governments cannot enforce setbacks that are more than 2 miles. And also, the local government can enforce their own environmental protections as long as the farming operation is in compliance with state and federal laws. So sometimes they are freestanding as well, and those are the ones that are really hard to find. So ideally, you would have someone looking at all of the bills that are coming out, but I know that's not possible for everybody.
All right, well, I guess, are there any more questions? We're about time to wrap up anyways, but everybody give Professor Winders another hand.